The Honorable Chief Justice and Associate Justices of the Supreme Court of North Carolina. Oh yes, oh yes, oh yes, the Supreme Court of North Carolina has resumed sitting for the dispatch of business. God save the state and this honorable court.
Good afternoon, Council. Our next case is the estate of Melvin Joseph Long, by and through Marla Hudson Long, Administratrix versus Fowler et al., and we will hear from the appellant.
Good afternoon, Your Honors, and may it please the court. My name is Sarah Boyce, and I will be presenting argument along with my co-counsel, Jonathan Hall, on behalf of the state employees. I will address the issue of sovereign immunity, and Mr. Hall will address the 12b6 issues. We will be happy to regulate our own time, but would ask to reserve 5 minutes for rebuttal. According to this court's precedents, to ascertain whether a defendant has been sued in his official or individual capacity, the court must identify the nature of the relief sought. In this case, as the record shows and as opposing counsel has acknowledged, if plaintiff's claim is successful, her recovery will come from the state. That fact means that this case is necessarily a suit against defendants in their official capacities. Plaintiff has sought to frame this case differently through artful pleading, but this court should reject that effort and reverse the decision of the court below. Any other result would put a target on the backs of individual state employees and would subvert the General Assembly's efforts to route these kinds of tort claims to the Industrial Commission. This court's decision in Meyer v. Walls squarely holds that, quote, the crucial question for determining whether a defendant is sued in an individual or official capacity is the nature of the relief sought, not the nature of the act or omission alleged. I'll let my friend Mr. Thompson speak for himself, but I believe I'm correct in saying that the parties here agree that the Meyer test is the test that this court should apply. That test resolves this case in favor of the state. And the reason for that is threefold. First, the rules about tort liability set forth under the Tort Claims Act and the Defense of State Employees Act make clear that any recovery that the plaintiff might receive in this case would come from the state. Second, both the record and statements made by opposing counsel in the prior argument in this case confirm that what the plaintiff here is seeking is in reality a judgment for damages from the state. And third, the notion that plaintiff is seeking damages from the state is not contradicted by the complaint in this case. If I may, I'd like to walk through each of these 3 points at slightly greater length in turn. First, turning to the statutory scheme. Section 300.3 of the Defense of State Employees Act authorizes the state to defend state employees who are sued on account of an act done or omission made in the scope and course of their employment. Section 300.4 of the Defense of State Employees Act sets forth 4 specific circumstances in which the state must decline to defend an employee. But assuming those grounds are not present, the state can undertake a defense of a state employee, and in the vast majority of cases, it will. Next, Section 300.6 of the Defense of State Employees Act states that when the state does decide to defend a state employee, the state will pay any final judgments or settlements. So these provisions working together make clear that in a broad swath of cases, when you sue a state employee, the damages necessarily will be coming from the public fisc. Here, the record in this case makes clear that the nature of the relief that plaintiff is seeking is in fact damages from the state. There are documents in the record at pages 98, 99, and 104 that make clear that the state employees are being represented by the state. And of course, that also explains my presence here today. And that means that this is a case covered by the Defense of State Employees Act and that any damages that Mrs. Long is seeking will come from the state.
Counsel, can you help me understand in Meyer, it says a plaintiff may maintain both a suit against a state agency in the Industrial Commission under the Tort Claims Act and a suit against negligent employee, agent, or employee in the General Court of Justice for common law negligence. What are we to make of that? I mean, that seems to have been the tradition of our cases for a long time, that you can be, that a plaintiff can go both to the Industrial Commission against the state and against an individual for common law negligence.
Yes, Your Honor. So the state does not dispute the notion that in the abstract, it is possible for a plaintiff to go both to the Industrial Commission and to Superior Court seeking damages. In this case, however, we believe that the Meyer test sets forth the appropriate test, the Meyer case sets forth the appropriate test, and where in fact the plaintiff is seeking damages from the state, that decides the case. But to give you an example of where this where that language from Meyer might still obtain, if, for instance, the decedent in this case had entered NC State's campus and perhaps been struck by an employee who was intoxicated driving a vehicle or something like that, that might be an instance where the decedent's estate could then sue both NC State, perhaps for negligent supervision, and the individual employee, because in that particular circumstance, the state is unlikely to be defending that employee, and damages against that employee in his individual capacity are unlikely to come from the state. So I do think that there
Isn't that a course and scope of employment question? Is that, I mean, because once somebody becomes, drunk in their employment, they've stepped outside of their the duties of employee.
It could be, perhaps, Your Honor, yes, and that might be one of the reasons that the state would decline in that instance under Section 300.4 to defend that employee and pay the judgment. But I'm simply offering that as an example of a case that would continue to be available, or an example of a fact pattern that would continue to confirm that the scenario in Meyer it confirms that what Meyer said about a plaintiff being able to pursue both an official capacity suit and an individual capacity suit still remains true. We simply think that here, where the General Assembly has gone to great lengths to take certain claims off the table by clarifying that, in fact, those claims are claims against the state instead of an individual employee, that those kinds of claims where the state is the real party in interest and where it's the public fisc that is open to a damages remedy, those suits need to proceed in the Industrial Commission. So I do think it's a difficult question.
Ms. Boyce, if the claim needs to, the Industrial Commission, of course, limits you to a suit against the agency based upon the negligence of the individual employee, at least as I understand it. If that's wrong, straighten me out now.
No, you're correct, Your Honor. In the Industrial Commission, the suit would technically be against NC State as the party in interest, and the complaint would identify the specific employee whose alleged negligence gave rise to the event. But as Your Honor has stated, technically the suit is against the agency itself or the state itself.
And in fact, there's no jurisdiction over the individual employee in the industrial.
Yes, that's correct, Your Honor.
So it seems to me, maybe in the ultimate question I'm getting ready to ask is my understanding correct? I'm hearing your argument to mean, in effect, that in the event that a plaintiff exercises his or her right to file a common law tort claim against a state employee acting in the course and scope of his or her employment, that claim, despite what our earlier cases say, is now barred by sovereign immunity, at least in the case of a state employee?
Your Honor, I don't think the court needs to go quite that far in this case because, as I'll continue to discuss, I think that the test set forth in Meyer makes this case easier than other cases might be. But it is true that the state's position is that in enacting the Tort Claims Act and the Defense of State Employees Act, the General Assembly narrowed the range of claims that might be available against an individual employee. So such claims may still proceed in certain circumstances, but I do think it's true that many of the claims that arise out of an act or omission in the course and scope of employment are now official capacity claims such that they need to go to the Industrial Commission. But again, I don't think this case requires this court to resolve that, because in this particular case, I think the complaint is ambiguous enough and the course of proceedings as this case has proceeded have made clear that this plaintiff is seeking damages from the state regardless of whether such suits will remain available in other cases.
What is that assertion? I think you're probably going to get ready to get to this, but let me give you a segue. What about the complaint, at least, makes it ambiguous as to what the nature of the relief that the plaintiff is seeking is.
In particular, in the prayer for relief, Your Honor, the complaint seeks damages, and it says it seeks them from the defendant, but does not specify whether it seeks those damages in the official or individual capacity from those defendants. So we would submit that ambiguity tips this case in favor of the state. There are, of course, statements in the complaint the state would concede that do suggest otherwise, that suggest perhaps this is an individual capacity complaint. But the ambiguity of the prayer for relief addressing the remedy, we think is significant, as well as, of course, the fact that these allegations mirror identically almost the allegations in the Industrial Commission complaint and the emphasis in the complaint on the course and scope of employment. So together,
I mean, I'm looking, Ms. Boyce, I'm looking at the addendum clause of the complaint, and it says, wherefore, having stated claims against the defendant individually and jointly, state of Melvin Joseph Long prays that have and recover defendants jointly and severally as follows. I mean, doesn't that say that there's stating claims against the defendants individually?
Your Honor, the state's reading of that brief is, or of that language, is that it's talking about the fact that the defendants might be liable collectively versus on their own, but that it doesn't necessarily clarify the question of individual versus official capacity.
Would you be making the same argument if it said having stated claims against the defendant in their individual capacity and jointly?
I think that would be much more complicated with respect to that particular aspect of the complaint, Your Honor. I do think that would be clearer, but I do think that the prayer for relief is only one component, and it goes and it is added on top of the identity between the substantive allegations, the focus on the course and scope of employment component of this case, and the various statements that have been made in the briefs and at oral argument below, acknowledging the fact that this is a case seeking damages from the state. So on that latter point, the relevance of those.
I'm sorry, but I do want to follow up on what you just said.
Sure.
So I first thought your argument was these employees cannot be sued individually because of the state's Defense of Employees Act. But now it sounds like you're saying, well, they could have been sued in their individual capacity, but this complaint just didn't sufficiently make clear that that was the intent. So which is it?
Sure, Your Honor. So I think the court has two options available to it. One would be a narrower ruling and one would be broader. So I do think in this particular case, the plaintiff has not sufficiently made it clear through the complaint that the plaintiff is seeking damages. So the court could rule on that very narrow ground that in this particular case, the plaintiff has not done enough to establish that this is an individual capacity suit. That would be a narrow path forward for the court. Another option for the court that the state would also believe is correct is to say that the General Assembly has essentially taken off the table these kinds of suits against individual employees. And we would certainly argue that that's consistent with the framework of the Tort Claims Act and the Defense of State Employees Act and the way that those acts seem to direct all claims that arise from an instance like this or a circumstance like this toward the Industrial Commission. So in short, go ahead, Your Honor.
Well, and so is it under the second more broader ruling, do I understand you to be saying that it's within the state's discretion to decide whether or not they're going to defend a particular suit or not, but once they decide they're going to defend the suit, then sovereign immunity applies? Or is there some category of cases where, because your example of the drunk employee, is there some category of cases where plaintiffs can be on notice that there won't be a defense by the state, and some other category of cases where plaintiffs would know that the state would defend? Or is it just case by case decision by the state?
Your Honor, I think as a general matter, state employees can be on notice that ordinarily when an act or omission occurs in the course and scope of their employment, the state is going to step in to defend. Your Honor is correct that it is ultimately discretionary, and there are also other instances under 300.4 that can lead the state to decline, such as where actual malice is present. But I think as a general matter, a state employee can feel relatively comfortable that so long as they are acting within the course and scope of their employment, that the Tort Claims Act and the Defense of State Employees Act will direct such claims to the Industrial Commission, and that judgments will be paid by the state. But again, this particular case does not require the court to make such a broad ruling. In this particular case, we have both the ambiguity that's present in the complaint, and we can look to the course of proceedings in this case, which the court explained in Mullis versus Seacrest is also a relevant consideration. Now, this court did not explain at great length what course of proceedings is supposed to mean, but that phrase was drawn from two U.S. Supreme Court decisions, Kentucky versus Graham and Brannon versus Holt. And in those decisions, the Supreme Court was trying to ascertain whether or not a particular suit was against employees in their individual or official capacities, and looked to statements in, for example, the trial court briefing, statements that the counsel had made in their opening statement, and used those various statements and clues to ascertain the actual nature of the suit. So here, the relevant evidence of the capacity, the kind of suit that we have here, would be primarily statements that opposing counsel made in the Court of Appeals below, and I would in particular direct the court to his statements in rebuttal, where he clarified that the judgment that these plaintiffs were seeking would come from the state, and explained to the court how the Defense of State Employees Act would work. So I would refer the court to that evidence, as well as the evidence in the record that this is a Defense of State Employees Act, where the state is stepping in to defend, and thus that the state will be paying the judgment. And the evidence in the record on that would be at pages 98 and 99 and page 104, as well as at page 17 of the plaintiff's brief. In short, for all of these reasons, as a doctrinal matter, we believe this court should hold that the defendants have been sued in their official capacity. If I may, I'd like to spend the rest of my time briefly focusing on why that conclusion is critical as a practical matter as well. Practically speaking, if the Court of Appeals decision is allowed to stand, a range of negative consequences would flow from that. First, it will create a perverse incentive for plaintiffs to always forego claims against the state in the Industrial Commission in favor of suits against state employees in their individual capacities. Ordinarily, if we think about a tort that might happen at the hands of a private employee in the course and scope of their employment, the injured party has a choice between suing the employer or the employee. And we can ordinarily assume, based on the relative wealth as between the employer and the employee, that the injured party will choose to sue the private employer, meaning that employees are unlikely to be stuck with crippling judgments. The Court of Appeals decision turns that paradigm on its head. Following the Court of Appeals decision, an injured party will know that it can only get $1 million if it sues the state in the Industrial Commission, but if it sues the state employee in Superior Court, then the party will have the option to get a greater damages award. So thanks to that disparity in the terms of the potential damages available, there is a clear incentive to injured parties to sue individual state employees. And that perverse incentive is a problem for a whole host of reasons. First, it threatens to open state employees up to crippling damages awards. Basically, just to give the court a little background, the way that these payouts work is this. The state purchases an excess coverage insurance policy, and there's both a cap on the amount that the insurance can pay out for an individual claim and a cap on the amount that the insurance company can pay out in the aggregate. If plaintiffs like Mrs. Long are permitted to sue individual employees, she would recover the first $1 million of any damages award from the state, and then a certain amount from the state's excess insurance policy, and then anything that's left will fall to the individual employee because the state law caps what the state can pay. Worse still, these crippling costs are going to fall exclusively on lower level state employees. Those employees who are more senior and who have more discretion are more likely to be public officials immune from any individual liability. It is state employees like the maintenance men in this suit, state employees like teachers, like janitors, who will lack any protection and risk facing judgments that wipe out their assets and savings. This risk of liability, in turn, could lead to serious obstacles for the state in terms of its ability to recruit individuals to enter public service. The threat of facing multi-million-dollar judgments because of mere negligence on the job is likely to deter good but risk-averse people from entering public service and being willing to work for the government. And finally, the holding below is likely to render the Industrial Commission and the Tort Claims Act almost entirely obsolete. Anyone who is injured by a state employee has no reason anymore to go to the Industrial Commission to seek payment from the state. Instead, injured parties will simply sue the relevant individual employees in superior court. This cannot be what the General Assembly intended. In passing the Tort Claims Act, the General Assembly clearly sought to funnel claims that arise out of a state employee's negligence in the course of their employment to the Industrial Commission. And in passing the Defense of State Employees Act, the General Assembly surely intended to protect state employees, to defend them, not to create a perverse incentive that would put a target on their backs as potential defendants. Because the decision below would undermine both of these goals, and because it is inconsistent with the legal test set forth in both Meyer and Mullis, the decision below must be reversed. And if there are no additional questions from the court, I'll turn the remainder of my argument time over to my co-counsel. Thank you, Your Honors.
Thank you, Ms. Boyce, and may it please the court, I'm Jonathan Hall, and Pat Meacham and I of Parker Poe have been retained to represent the state of North Carolina and its employees in this lawsuit as outside counsel. I am going to address just the 12B6 aspect of all of this, and while I've been relegated to just a little bit of time, I don't want that to be any indication of how unimportant or that it's unimportant that we have these arguments heard. And in fact, these the 12B6 considerations, it was a proper order by the trial court to dismiss the claim based on a lack of proximate cause and based on the punitive damages being inadequately pled. If I may, the complaint here was properly dismissed by the trial court because it failed as a matter of law to contain the requisite facts to establish a proximate cause relationship between the alleged failures on the part of NC State's maintenance personnel and the catastrophic damages sustained by Mr. Long. We acknowledge, first of all, that dismissal of a complaint for negligence at the 12B6 stage based on proximate cause is uncommon. It's not favored in our state. But if there's ever been a case that is appropriate for dismissal based on 12B6 and a lack of foreseeability, it's the case at bar. The complaint itself incorporates the facility's work order under which these employees were performing the job. And if the court please, on the facility's operations work order itself, it says what these employees were supposed to do was to please drain and secure the carrier chiller for relocation. There was nothing in the work order that said they were supposed to winterize the machine or get it ready for long-term storage. The complaint also included a warning from the machine itself, and it said freeze warning. It said it is not possible to drain all water from this heat exchanger. For freeze protection during shutdown, the exchanger must be drained and refilled with essentially antifreeze. Then paragraph 43 of the complaint talks about the operating instructions from the manual for the chiller unit. And it says under winter shutdown preparation. Okay, and again, we suggest to the court in the complaint itself, it doesn't say these employees were asked to winterize the machine or shut it down for the winter so it wouldn't freeze. They were asked to simply drain it so it could be moved. But under this warning, under winter shutdown preparation, it says at the end of each cooling season, the fluid should be drained from the system. However, due to the cooler circuiting, I'm not sure where that word came from, but cooler circuiting, some fluid will remain in the cooler after draining. The important part here is it says to prevent freeze-up damage to the cooler tubes, perform the following procedure, and then it talks about you need to put antifreeze in it. The complaint talks about the fact that these employees did exactly what they were asked to do, which is they drained the machine. The complaint says, well, they didn't drain it completely and therefore the machine got pressurized, but there is nothing on the warnings for the machine or in the manual which suggests a possibility even that a failure to properly drain it would result in some sort of cracking of the tubes, but then a pressurization of the machine that then would lead to some contractor coming along and taking one of the lids off the machine and being injured by it. There's just no foreseeability here. And this is exactly the situation that then Judge, later Justice Cardozo, contemplated in a Pulsegraph case. It's remarkably similar to the Pulsegraph facts, where you've got but-for negligence, but we don't have foreseeability here. There is nothing in this complaint which suggests these employees should have known that a possibility of their conduct would be that this machine would somehow freeze up and then pressurize and then hurt somebody. It's just not in the complaint. So with that in mind, we suggest that the trial court was appropriate in dismissing the claim based on a lack of foreseeability. Very quickly on the punitive damages claim, which is no less important. But as the court knows, the General Assembly passed Chapter 1D in the 1990s, and the purpose of that was to try to put an end to these perfunctory claims for punitive damages whenever someone's been seriously injured. And the statute, the plaintiff here spends a lot of time in her brief and her word count on talking about, well, our allegations of the complaint are pulled straight from the statute. And that's true as far as characterizing the conduct that they're talking about. But that's not the test. As the court has said in the Yancey case that we quoted in our brief, Justice Lake in 2001 said that gross negligence is wanton conduct done with conscious or reckless disregard for the rights and safety of others. An act is wanton when it's done with wicked purpose or when done needlessly, manifesting a reckless indifference to the rights of others. It says to rise to the level of gross negligence, the act is done purposely and with knowledge that such act is a breach of duty to others. In other words, a conscious disregard for the rights and safety of others. If you look at the complaint, at most, again, giving the plaintiff every benefit of the doubt, this is a should have known case, okay? The allegations that these employees should have known that by not draining the machine, it could freeze, that the freezing could cause a crack of the pipes, and that the crack of the pipes could then lead to a pressurization, and that the pressurization could then lead to, they call it a booby trap, but a possibility of injury to an employee or to someone that comes along later and works on it. But the fact is, again, that's should have known. Punitive damages, wanton and willful conduct requires clear and convincing evidence that they knew there was a probability that someone was going to get hurt, and they did it anyway. And the allegations of this complaint, as far as the allegations of fact, not the characterization of what they did, but the actual allegations of what they did, don't rise to that level. And for these reasons, again, I'm sorry to be so short, but we respectfully suggest that the Court of Appeals opinion that reversed the trial court should itself be reversed, and that the order of dismissal entered by the trial court be reinstated. Be glad to take any questions, and thank you for your time. I'm sorry I had to speak so quickly.
Thank you, counsel. We will hear from the appellee.
Good afternoon, Your Honors. John Paul Godwin and I represent the estate of Marla Long. I'm going to speak to the immunity issues, and Mr. Godwin will speak to the 12b6 issues. First, in this case, the defendants, 6 individual state employees, are asking to take away the rights to have a jury trial by the estate of Joe Long. And we ground our case, rather than talk about a lot of things off the record, I'd like to look historically at what this court has recognized to be the rights to pursue claims in North Carolina. For more than 80 years, the North Carolina Supreme Court has sanctioned common law claims for negligence in the general courts of justice to pursue claims where public employees were negligent. The case Miller versus Jones is a case that's cited by both parties. It came down 76 years ago, but if the court reads Miller versus Jones, it refers at page NC 224-787 to a case called Hunter or Lewis versus Hunter, which actually happened 84 years ago. And so for decades, this court has allowed common law claims against public employees for negligence. In 1951, after those 2 cases were decided, the legislature passed the State Tort Claims Act. And thereafter, there were 2 avenues that a party could pursue for recovery. They could pursue a claim against the state or an agency via the State Tort Claims Act, and they could continue to pursue a claim against an individual public employee in the General Court of Justice. The case that we have cited, Worth versus Bracy, is a 1963 decision from the Supreme Court, where Justice Bobbitt explained that there was the right to pursue both claims and that jurisdiction is mutually exclusive. One cannot pursue a claim against an individual in the Industrial Commission, and likewise, a claim against the state or an agency cannot be pursued in the General Court of Justice. Something I think that's important, if you'll turn to the record at pages 31 and 32, after the Industrial Commission claim was instituted, the parties agreed a consent agreement that was signed off on by the state and private counsel at Parker Poe, that the individuals who were named in that case were dismissed from the claim, and the only thing that remained in the tort claim action was a claim against NC State. Several months later, this complaint was filed in Person County Superior Court, and the tort claim has been stayed pending the outcome of the General Court of Justice action pending in Person County. Now, we've heard a lot about the Defense of State Employees Act, and as I read General Statute 143-300.3, and I think this is important, it says that the state may defend an employee or former employee of the state in a claim brought against them in their official, and I'm reading from the statute, or individual capacity, or both, on account of an act done or omission made in the scope and course of employment as a state employee. So, in our view, Your Honors, this contemplates that there can be individual capacity claims against state employees pursued, and we know from what we've heard from the defendants that those claims can only proceed in the General Court of Justice. Now, the case of Meyer versus Walls is a case that has been cited by both parties. And there's a quote in that case that I think is important. At page 100, this is 347 NC at 111. It says, thus, official capacity is not synonymous with official duties. The phrase is a legal term of art with narrow meaning. The suit is in effect against the entity. So official capacity doesn't look at the prayer for relief. It looks at the intent of trying to pursue the claim directly against the individual or to pursue the claim against the agency. That case relies upon the Miller versus Jones case. There is a case that is cited and quoted by the appellants in their brief, and that is a case called White versus True. And there is a quote from that case. This is 366 NC at page 363. It says, a suit against a public official in his official capacity is a suit against the state. And we contend, Your Honors, that means that there are two factors that need to be weighed in the consideration of these claims. First, is the individual a public official? And then, is the claim being brought in that public official's official capacity? So what makes one a public official? This court has given guidance in the case of Eisenhower versus Hutto, which is cited in our brief, and it sets forth various criteria. Was the job created by the Constitution? Was it a job created by statute? Does the person exercise the sovereign power of the state? The factors are set forth in that case. There's a Court of Appeals decision that also suggested, this case is Murray versus County of Person, cited in our brief. It suggests that a public official is someone who holds elected office or takes an oath of office. Regardless, we have examined in our brief at pages 15 and 16 a number of different criteria about what makes one a public official. So that brings us to, how did we plead this case? And without talking about the 12b6 issues, the question that we believe is relevant is, did the complaint follow the guidance of our courts in pleading a legitimate individual capacity claim against these 6 men? The Mullis versus Seacrest case is a template or form, if you will, that gives us lawyers a chance to look at how we should properly plead a complaint. And in the complaint that we have, which begins in the record at page 37, on the first page in the caption, we referred to these defendants individually. In the preamble paragraph, it says that we're seeking relief from these gentlemen in their individual capacity. There are separate causes of action against each individual. As Justice Irvin pointed out, the prayer for relief, the preamble before the actual prayers says individually and jointly and/or jointly and severally. There are separate claims against each of the individuals.
If I understood Ms. Boyce's argument correctly with respect to this point, she, I think, told me that the reason that this was not, didn't clearly state, this complaint didn't clearly state an individual claim in the ad damnum clause was because the language that you used was susceptible to the interpretation that you were seeking, what amounted to joint and several liability, and that the reference to individual or individually in the ad damnum clause didn't mean read in context that you were asserting damage claims against these individuals individually. What's your response to that, assuming I'm somewhere close to what her argument was?
Well, Your Honor, I've got to confess, when I heard joint and several, I thought, my gosh, I know there's a case that we've cited, and it says pleading joint and several is an indication that you're seeking an individual capacity, that you're making a claim in individual capacity. But y'all probably saw me shuffling my papers. I could not find that. But by having 6 individuals whose negligence may have concurred, we are simply making the claims individually, but we're not seeking. There is not an agency allegation in the complaint. There's not a respondeat superior allegation. There is no way where we're trying to impute liability to the state or an agency of the state. But I wish I could reach down and pull that quote out because I loved it, but I can't find it.
Mr. Thompson, can I ask you a quick question, I think?
Yes.
In the beginning of the complaint that you sent us to page 37 to look at, that intro clause for the whole complaint says that here they come complaining of the defendants in their individual capacities, jointly and severally. Does that not apply to the whole rest of the complaint, or does it only apply to the first part of it?
I think it applies to the entire complaint. Without the ability to conduct discovery, we're not sure if all 6 of these individuals or some combination of them would be the negligent party. And if we're allowed to proceed and we're put to our proof, then I think that will become clear later on. So there's a reference there, and there's also a reference at the end. I think it's page 67. And there's nothing about using the words joint and several, we believe, that changes the fact that this is an individual capacity claim.
Right, well, it says individually and jointly,
Right,
and then jointly and severally, so it says both.
right.
Wherefore clause.
Well, and we have alleged in the complaint, and I know this is pointed out in our brief, these particular elements as to each individual that would prove that they are not public officials. Their jobs were not created by statute or constitution. I know this is getting ahead of a Rule 12 motion, but the answer is part of the record on appeal. And these defendants have admitted that they do not satisfy any of the criteria for a public official. They have, everyone admitted each one of those allegations that are set forth in more detail. And in the complaint, I believe it is at pages 14 and 15 of our brief. I said complaint, but I meant brief. I'm happy to answer any further questions that you have, but for more than 80 years, the type of claim that we have made has been sanctioned by this court. And we have done our best to follow the guidance of the decisions about how to plead it. And we've believed that we have complied with the criteria of Mullis versus Seacrest, so that there should be no mistake by these 6 individuals that this is a claim in their individual capacity. I am happy to answer any further questions, but if there are none, I'm going to turn it over to Mr. Godwin.
Good afternoon. May it please the court. My name is John Paul Godwin, appearing on behalf of the appellee, and I'll be addressing the 12B6 issue. The complaint we filed in this case provides sufficient notice of claims for wrongful death, gross negligence, compensatory and punitive damages that are long recognized under North Carolina law. Our brief references several of the court's decisions regarding a motion to dismiss a complaint for failure to state a claim, one of which was Embry Construction versus Rafcor Incorporated. And I believe it was a 1992 case where Justice Exum wrote, on motion to dismiss a complaint for failure to state a claim, the complaint's factual allegations are taken as true. The court must determine whether the complaint alleges the substantive elements of a legally recognized claim and whether it gives sufficient notice of the events that produce the claim to enable the adverse party to prepare for trial. A complaint should not be dismissed under Rule 12B6 unless it affirmatively appears that the plaintiff is entitled to no relief under any state of facts which could be presented in support of this claim. He went on to say that in practice, the system of notice pleading affords a sufficiently liberal construction of complaints so that few fail to survive a motion to dismiss. We cited an additional case, Sutton versus Duke. That was a case from 1970, I believe, and Standback versus Standback, a case from 1979. And these cases hold that a motion pursuant to Rule 12B6, it tests the legal sufficiency of the complaint. In other words, does the complaint, again with the allegations taken as true, state a claim for which relief may be granted? And that a complaint complies with notice pleading requirements of Rule 8 if it gives sufficient notice of the events or transactions which produce the claim to enable the adverse party to understand the nature of it, the basis for it, to file a responsive pleading, and to use the rules allowed for in pretrial discovery to get any additional information that they may need. And that dismissal is not appropriate even if the claim was mislabeled or named wrong, if the factual allegations, liberally construed, would support any cause of action under a valid legal theory. And as Mr. Hall indicated, dismissal under 12B6 is disfavored by this court, and the pleadings will be liberally construed in the light most favorable to the plaintiff. We understand that in a negligence claim, proximate cause is a necessary element. We understand that the test of proximate cause is whether the risk of injury is within reasonable foresight of the defendant. And that makes proximate cause a factual question and not appropriate for a motion to dismiss under Rule 12b-6. Here, the appellant's arguments on the issue of foreseeability are basically urging resolution of facts by this court, which is not proper. The complaint we filed correctly recites the elements of causation, again, an issue of fact for the jury to decide, and therefore makes a sufficient pleading of causation under Rule 12b-6.
Mr. Coleman,
Yes,
Mr.
ma'am.
Coleman, in their brief and also in argument today, the argument was made that there were insufficient allegations that what happened was reasonably foreseeable. And I understand that you're saying based on the rules of pleading that it's sufficient. Can you point us to the parts of the complaint that you say are adequate statements of foreseeability?
Well, in the allegations that we make with regard to each of these defendants, there are 18. And it also has a provision that discovery may lead to additional bases of how each defendant was negligent. But we include claims that for each defendant that he knew or should have known that there was still water in the cooler tubes, that he knew or should have known that the cooler tubes could be damaged and the water tubes and pipes would become pressurized, and that he knew or should have known that pressure would build up inside the chiller when he capped this massive machine. I would also point to the fact that the manual and the warning itself on the machine point to freeze damage that can occur if the unit is not properly winterized. And so what we allege is that they knew or should have known that their negligence would likely result in injury or death, and that Mr. Long's death was a proximate result of one or more acts or omissions of each defendant. So, Your Honor, to answer your question, we believe that these allegations taken as true make a sufficient pleading of causation under Rule 12b-6.
Well,
Is there an indication? I'm sorry, go ahead, Justice Hudson.
I just have one little question. So I'm looking at paragraph 151, for example, which is an allegation under the first cause of action, which says exactly that what you said, some are all the acts or omissions demonstrated conscious or intentional disregard, and that they knew or should have known would be likely to result in injury or death. I take it that kind of paragraph is repeated for each of the claims for relief?
Yes, Your Honor.
That's all.
Thank you.
Where is there an indication that these employees were required to winterize this equipment?
Well, with regard to the work order that was cited earlier, that was made a part of the record, their job was to shut this machine down, and because of the warning and because of the operation manual when it was to be shut down, and especially if it was to be capped, the time that they did it was in December. And so there are freezing temperatures, and they knew that there would be freezing temperatures outside where this machine was, because it was on the back of a trailer outside of a building, taking up the entire trailer. This is a massive machine. And because of the temperature outside and because it was winter, we believe that it should have been properly winterized, as was the operator manual and the warning on the machine had indicated.
The precise instruction was drain and secure carrier chiller for relocation. How does that mean winterized?
Well, I think, Your Honor, when we are talking about securing it, and even if we're talking about draining it, these defendants, they should have been cognizant of how this machine works, especially from the warning label on the machine itself and from the operator's manual, that if you're going to shut it down and if you're going to drain the water out of it, you have to know that not all the water can be drained, and that when it gets down to certain temperatures, that there's going to be damage to the machine itself if it's not properly winterized by putting antifreeze in it. And so the freeze warning itself, it says it's not possible to drain all water from this heat exchanger. For freeze protection during shutdown, exchanger must be drained and refilled with 5 gallons of glycol. And it has a big thing under it in big words, trapped water, exclamation point. And that's paragraph 42 and 43 of the complaint. And the shutdown procedure in the instruction manual was in page 48 as well. So we believe that these maintenance employees, if they're going to be working on this type of machine, they have to follow the instructions, to properly store it and to properly secure it. And so, Your Honors, taking the allegations of the complaint as true, it was reasonably foreseeable to the defendants that by disregarding the warning signs and winterizing instructions and capping the water pipes, that this machine would become pressurized and present a serious danger to whoever loosened that flange. And these allegations of foreseeability are not unreasonable inferences, but are clearly supported by the allegations taken as true within the complaint. And so the complaint, it gives sufficient notice of the nature and the basis of plaintiff's claim to enable the defendant to answer and prepare for trial. And indeed, they have filed an answer and raised affirmative defenses.
Do you believe for gross negligence that there needs to be more than conclusory allegations? In other words, there has to be some factual allegations with regard to there being a conscious disregard.
Your Honor, with regard to the punitive damages, the allegations that we made, are taken directly from Chapter 1D. In the complaint, it was alleged that each defendant's conduct was willful or wanton and, quote, demonstrated a conscious or intentional disregard or indifference to the rights and safety of others, including Joe Long, which they knew or should have known would be reasonably likely to result in injury or death. We made allegations with regard to them ignoring these clear warnings on the machine and in the operator's manual. And we understand that we have to plead facts that support that, but taken as true with regard to this stage, this pleading stage, we believe that these allegations that we've made in the complaint, taken as true, are sufficient. And so we respectfully ask this court to find that the complaint contains allegations, which again, taken as true under notice pleading, and the inferences from these facts, that they are sufficient to state claims for negligence, gross negligence, and punitive damages. Respectfully, Your Honors, that the estate should be allowed to then conduct discovery and have our case decided on by the merits by a jury. And I'll take any other questions that the court may have. Thank you.
Thank you, counsel. Rebuttal.
Thank you, Your Honor. My friend, Mr. Thompson, directed the court's attention to Section 300.3 of the Defense of State Employees Act, which authorizes the state to defend state employees when suits are brought both in their official against those employees in their official and individual capacity. And I do want to be very clear that it is not the state's position that individual capacity suits can never be brought. The Defense of State Employees Act, of course, applies in a broader category of cases than just tort claims. It would authorize the state to defend state employees in constitutional claims, contract claims, and the like. But even in the tort context, the state's position is not that individual capacity suits may never proceed. I do think it's a much harder question whether the passage of the Tort Claims Act and the Defense of State Employees Act have effectively eliminated individual liability when acts and omissions occur in the course and scope of an employee's employment. Of course,
this statute's been in effect since 1967, hasn't it?
Yes, the Defense of State Employees Act has been in effect since 1967, though the provisions of the act relating to the state's payment of judgments has not been quite that long.
Well, and I missed that. Then when were they enacted?
Those were enacted they were revised and adjusted throughout the 1970s. So still for quite some time, Your Honor.
Has the state advanced this theory before in the 40 to 50 years since the enactment of the Defense of Employees Act?
The theory being that individual liability may have been eliminated in these kinds of claims?
Yes.
No, Your Honor, I don't believe that this particular theory, as far as I'm aware, has been advanced.
And it is true, isn't it, that whether the state chooses to defend these employees is discretionary with the Attorney General office and with the ability to delegate the decision to the department head.
Yes, it's discretionary insofar as the state chooses to defend. There are circumstances where that discretion is limited and the state is forced to decline, but with respect to accepting representation, it is discretionary. But again, this particular case does not require the court to issue a broad holding about the availability of individual capacity claims broadly in the tort context or anywhere else. All this case requires...
I understand you have the narrow holding and the broad holding, but on this broader question, don't we essentially have to overrule Eisenhower and Mayor v. Wells to reach that outcome?
I think it depends on how broadly you read those cases, Your Honor. I read those cases simply to confirm that in some circumstances, an individual capacity suit can be brought for negligence and a suit may be brought against the state. So insofar as those cases stand for the proposition that individual and official capacity suits may proceed simultaneously, then no, I don't think they need to be overruled. If you have a broader holding or a broader understanding of those cases, then yes, it may be necessary to revisit them. But I do think that this court can faithfully construe them in that narrow manner and nevertheless find that the Defense of State Employees Act, working in conjunction with the Tort Claims Act, has cut back on the liability of state employees.
Thank you, counsel. I believe your time's expired. Thank you, everyone.
Thank you, Your Honors.
Oh yes, oh yes, oh yes, the Supreme Court of North Carolina is now in recess. God save the state and this honorable court.